You're watching The Legal Breakdown. So Glenn, we have our first controversial ruling passed down by Judge Cannon in the federal trial against Trump. So the way it's being framed right now is that Jack Smith wanted to file the 84 potential witnesses against Trump under seal, but that Judge Cannon denied that request, meaning those witnesses would be handed over to the Trump team and made public, which would then, of course, open them all up to targeted harassment. Is that what happened here?
You know, that is sort of what happened, but it's not quite as ominous as it sounds, because right now, the names of the witnesses have not been filed in court, so there is no risk yet of them being disclosed publicly. The reason they are not yet filed in court is because, as you say, Special Counsel Jack Smith filed a motion seeking to turn over the names, the 84 names of the witnesses, to the court only if the court would agree to file them under seal. Judge Cannon denied that motion in total. So what that means is that the court doesn't have the list of witness names. The court has not agreed to file them under seal if Jack Smith persists in his request to file them with the court, and everything has been returned to the status quo. This one's going to take just a minute to unravel, but let me give it my best shot. So when Donald Trump was arraigned on the indictment, you may remember that wasn't Judge Cannon. That was a magistrate judge, Judge Reinhardt, who arraigned Trump and set some conditions for his release. One of the conditions was that he should have no contact with the fact witnesses. But it was a little unclear, based on the wording of the release order, whether the prosecutors had to turn over the names of those fact witnesses to the court, or was it sufficient that they were going to be giving discovery to Donald Trump's defense team that included the names and identities of all those witnesses, such that if Donald Trump violated the order and started contacting and intimidating and harassing the witnesses, he would be hauled into court for a contempt hearing. So what Jack Smith just tried to do, it's kind of just almost a precautionary measure. He said, you know what, Judge, just to implement that part of the protective order, I'm offering the court a list of the names of those 84 witnesses only if you'll file this list under seal. Judge Cannon said, no, I'm not going to file it under seal, so I'm going to reject your motion entirely. Here's the thing, Brian. When prosecutors file a motion to seal, there is actually a pretty high bar. There's a pretty exacting standard that we have to prove to the judge's satisfaction before a judge is willing to seal any matter. Why? Well, the Sixth Amendment provides for a public trial. The First Amendment, freedom of the press, provides generally that the media has the right to access public trials, as do the citizens. The people also have a right to access public trials. So interestingly, when Jack Smith filed this motion, this list of names, and wanted to put it under seal, a whole bunch of media organizations filed motions to intervene, saying, wait a minute, Judge Cannon, the prosecutor hasn't sort of met the standard to have these names sealed, and in the public interest, we want them. We don't think you should seal this prosecutorial filing. We want to report on it. And I think Judge Cannon said, you know what? If Jack Smith wants to persist in his request to give the court this list and file it under seal, you're going to have to make more of a showing than you already have. That is actually a justifiable call by Judge Cannon. I have been a mighty critic of Judge Cannon and will continue to be, because I don't know that she's the right judge to be presiding over this case, but I don't think she got this call wrong.
Okay, but now, just to piggyback off that, I know that there are First Amendment and Sixth Amendment considerations, but wouldn't the fact that we already know that the Trump team has a proclivity to obstruct justice and that his allies have a proclivity to harass witnesses who would testify against Trump, doesn't that supersede those general considerations about the First and Sixth Amendments?
No, very few things supersede the Constitution.
Or wouldn't they be considerations in deciding whether or not to ultimately, if it is granted at some point in the future, to ultimately hide those 84 witnesses' names?
Yeah, so here's where I definitely agree with you. I don't think those names should be made public. Why? Because we all know Donald Trump's supporters, some of them, will be inspired to, intimidate, to harass, perhaps worse, anybody who's a witness against, their false god, their political deity, Donald Trump. I mean, how many Shay Mosses and Ruby Freemans do we have to suffer, right? Those are the two Georgia poll workers who had their lives threatened because Trump and Giuliani falsely claimed that they were involved in, stuffing ballot boxes. We know Donald Trump's MO. We know the MO of Donald Trump's supporters. So I don't think those names should ever become public. But if the prosecution wants to file the list, they need to make the requisite showing that they've got the facts and the law supporting their request to file the list under seal.
All right. With that said, is there a world in which anything that happened here could be perceived as Judge Cannon helping the Trump team and basically setting up circumstances where they could obstruct justice? Or do you stand by this idea that what she did was justifiable?
In isolation, if we look at it in a vacuum, it was justifiable. But, the critics will yell and scream, appropriately so, that, this looks like she may be doing another favor for Donald Trump. And, Judge Cannon is the one who is responsible for those critics being able to plausibly argue she's doing yet another favor for Donald Trump because she did him a favor that violated the law. She did him a favor that was an abuse of her discretion. That, don't take my word for it, that was the 11th Circuit Court of Appeals who smacked her down and said she acted in a way that was not permitted in the law and that, she was doing a favor for Donald Trump. And it was an abuse of her judicial discretion. So here is where I will always settle on Judge Aileen Cannon. The federal law says it's a very simple standard. It sets out the standard for when a judge must remove themselves from the case. It's when their impartiality can reasonably be questioned. Given her history in this case, I think it is sort of the height of arrogance and hubris that she has apparently decided that none of us can reasonably question her impartiality. And she will suffer this kind of criticism every time she makes something that looks like it's doing sort of an unwarranted favor for Donald Trump.
Yeah. Glenn, is there any indication that the DOJ has sought recusal thus far or is moving to have her removed and replaced? And if not, could they? Has that ship sailed?
I think the ship may be pulling away from the dock, but I don't think it has fully set sail yet. So let's assume, Brian, that tomorrow Judge Cannon makes such an outrageous ruling in favor of Donald Trump that her impartiality is obviously in question. That could give rise to Jack Smith filing a motion to recuse. Now, I think he could have filed one earlier, and frankly, I wish he had. I think this case is too important to just sit back and hope for the best that Judge Aileen Cannon will right her own ethical ship. She's already been found by the 11th Circuit Court of Appeals to have abused her discretion and acted in a lawless way to the benefit of Donald Trump. I mean, do we really have to wait until she does it again to litigate the issue of the need to remove her from the case? I would have preferred if Jack Smith had filed the motion, let her rule on the motion to recuse in the first instance, which is how it would play out. Assuming she refused to remove herself from the case, then you appeal it to the 11th Circuit Court of Appeals and you get this issue resolved definitively. And then you've done everything you can to ensure a fair trial, not just for Donald Trump, but for we the people, because the people of the United States in criminal prosecutions have a right to a fair trial. It looks like Jack Smith is less inclined to do it. And I think with each motion that's filed and with each order that is issued by Judge Cannon, I think it becomes less and less likely that we're going to see Jack Smith file a recusal motion unless and until Judge Cannon does something that is equally outrageous, to her earlier abuse of discretion.
Yeah, but I mean, to your point, the fact that when we see rulings like this one that could certainly be perceived as helpful to Trump because of her initial actions helping the Trump team and interfering in that case on his behalf. Now we're in a situation where we basically, perceive everything she's doing as being helpful to Donald Trump. So, we'll keep an eye on this stuff as it continues to progress. If you want to stay on top of legal news, make sure to subscribe. The links are right here on the screen. I'm Brian Tyler Cohen.
And I'm Glenn Kirshner.
You're watching The Legal Breakdown.